Inside America's Boardroom, the informational show for board members and corporate secretaries. Brought to you with Knowledge Partners, NASDAQ, the Center for Audit Quality, and PwC. Along with content contributors, Equilar, Meridian Compensation Partners, Wilson Sonsini, Goodrich, and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of Inside America's Boardrooms. I'm TK Kerstetter, the CEO of Boardroom Resources, and it's my pleasure to welcome you to our part 2 of legal and governance issues critical to the board. And joining me again for part 2 is our legal advisor and expert to the show, Bill Chandler, who's the former Chancellor of the Delaware Court of Chancery and partner with Wilson, Sonsini, Goodrich, and Rosati. And Bill, welcome back.
Thank you, TK.
And we have a plethora of topics. We didn't do bad in the first part getting through some of those. We've got some meaty ones today, though, and we'll do our best to keep these as succinct as possible.
Sure.
But the first one is we have to talk about is activism, because that is really something that's happening a lot in our business world these days. In your home state of Delaware, you just had a very high profile with Nelson Peltz and DuPont. Mm-hmm. And directors are asking sort of what do they need to remember around activism and what are the proper steps, because it's almost becoming an issue that it's something that everybody needs to prepare for and think like an activist.
Well, I think that sums it up. I recently heard an index fund leader speaking to directors who said directors need to think more like activists, because that will help them be prepared. Because if you wait for an activist to appear and then begin to prepare, it's probably too late. And they are getting some success. I mean, I think in the latest round of waged proxy battles, the activist group had 60% or more that they either won or had favorable settlements. And so they also, it's not just confined to one particular industry. It's everywhere. It's Fortune 500 companies. It's in the tech sector. And so everyone has to, I think, be prepared for it and be ready. And there are a number of things that when I speak to directors that I think they are already conscious of, but I just sort of reinforce, which is they need first, I think, to realize their fundamental duty. Directors don't owe duties to any particular group or subgroup of shareholders or investors. Their duties of care and loyalty are to all of the shareholders of the company. And they have to act in the interests of all of those shareholders, not just those who happen to be the loudest voices or perhaps who have acquired a recent position in the company. That's number one. Number two, I think there are things that they need to be doing proactively, engaging with shareholders, making sure that management is engaged with their shareholders, understands what concerns their shareholders or investors might have about the company. Maybe there are issues about governance at the board level or the management level. Maybe there are issues about compensation. Maybe there are issues about whether a particular division of the company is doing very well and ought to be spun off. So there are a lot of things that the investors, I think, can communicate to the management team. And the question is the board getting that information? And then secondly, what is the response to that message, to that communication? How is the company perceived in terms of being able to, A, respond to those concerns, and B, actually deliver on their messaging about what they're going to do about those concerns? The next thing we recommend is that boards take a very careful look, and for this they need help from their advisors, either internal legal advisors or external legal advisors, about their structural defenses. That is, defenses that should be in place to protect the company from anyone trying to take a position and perhaps try to force the company to do something that really isn't in the interest of all the shareholders. That could be, rights plans or poison pills that are on the shelf that could be used in a crisis if needed. It could be, is the board subject to majority voting or something else? How are board vacancies filled? Does the board have the right to appoint directors to fill vacancies? Do the shareholders have the right to act by written consent? Can they call special meetings? And if they can, what percentage of shareholders does it take to call the special meetings? The board needs to be informed about what sort of structural defenses exist, whether any of them need to be buttressed or whether any of them are particularly weak or vulnerable. So that's an important thing they need to be doing. But the major key takeaway is the engagement with your shareholder base. Proactively, before the activists ever show up, you want to understand that. You want to be engaged with that shareholder base. You want to be engaged with the proxy advisory community. You want to be engaged with your analyst community, what they're saying and writing about the company, what the media is saying and writing about the company. If you're doing that and you're thinking like an activist, TK, you should be okay.
Well, this gets, for the last 3 years, as part of this show, we've been pushing this concept of shareholder engagement. And you can't wait until you have an incident. It's really something that you need to be doing. And so many boards today, Bill, still are not comfortable with that conceptually, And a lot of times outside counsel is nervous about that process. Sure. But there are ways, to do shareholder engagement so that you aren't, asking for support at the last minute from somebody that you've never, my mom used to call that the gimme prayer, where the last minute in time of need, all of a sudden you're reaching out. Well, same is true in the board. You have to try and develop the best relationship you can on that. And the interesting part about this is it's not just, it used to just be weak companies. Activists don't, they'll go after, somebody as strong as Apple as they will, weak companies. So another issue that we wanted to make sure that we paid a little attention to is proxy access. And we all know years ago there was an effort to put that in across the board. The U.S. Chamber led a group that sued the SEC about their abilities to do that. Once again, the SEC lost that battle. Private ordering was still in place, though, where you could go company by company. We've recently seen the New York Comptroller target 75 companies to institute proxy access within them. They've been successful in a number of those cases. We've also seen companies go on the front end of that and sort of come up with their own plan to present on proxy access. We saw GE, Citigroup, Prudential, a lot of them getting ahead of this curve and saying, we're going to take this issue off the table, we're going to present our plan and get it done. So if I guess one of the things that we should cover is when you're called in, what do you say to somebody? Is it the type of thing that you say, jump ahead of this, or wait, or what are the factors that a board should be considering?
Well, we get asked this often, TK, as you might imagine, and to sort of put bookends on the growth of this problem or issue. There were, I think, 14 or so proxy access proposals in 2014. And so far in 2015, I believe it's over 100 proxy access proposals. As you mentioned, they're often modeled after the SEC's rule that was invalidated, saying that if you're a shareholder of 3% or more and have held for 3 years or more, then you ought to be able to nominate a candidate to the board using the company's proxy and proxy card for up to 25% of the board members. Interestingly, though, I think the investor community has still got mixed views on proxy access, and that kind of shapes where we come out in terms of our recommendations to directors who ask us for advice on this. And that mixed reaction from investors is along the following lines. I mean, some investors feel that the 3% and 3-year thresholds are just too low. Some investors think that nominating and electing directors who are put forward by a particular sponsoring shareholder, who that director may reflect their views on perhaps a more short-term focus for the company, or on perhaps issues that aren't as long-term as the company would be thinking of, or has other issues that is sort of driving the agenda of that sponsoring shareholder, makes some investors wonder whether this could lead to ineffective governance at the board level. And so there are some who have some real hesitation. Other investors think that when a company has demonstrated that it's got some governance challenges going on, or it has a perception of not being receptive to shareholder concerns and issues, Perhaps it's failed a say on pay. Maybe it's just not done very well in say on pay votes. Think that that might be a basis for why proxy access is something to vote for. So all I'm getting at is there's a mixed reaction among investors. That's why we recommend that boards just sort of monitor evolving practices in this area and stay tuned. And if they're alert to whether they've got internal problems that might generate interest in proxy access, then perhaps coming up with their own proposal to preempt the issue with perhaps a 5-year, 5% or some different floor or threshold. But we don't recommend just automatically, proactively adopting proxy access unless there's a real problem that the company feels that it's going to be addressing. Either if it doesn't do it, it's going to have to address it when it has a proxy proposal from shareholders.
Yeah, I certainly understand at its core the desire for shareholders to play a role in who's going to represent them in the boardroom. I mean,
sure.
I think in its most basic form, we understand why they should have that ability to play some kind of role. But I think of it from a different angle. Imagine directors just inadvertently joining the board without thought of succession about committee chairs or whatever. Here's a board of a good company planning the types of skill sets that they need so that they can fill the key positions on the board, and all of a sudden they get an influx of people that have none of those skills, okay? Yet they're obligated to fill those committees and, you know, have very qualified people handling those chairs like audit chair and comp chair. So, you know, there's all kinds of arguments, and I think that's what makes this such a sort of a volatile topic.
I agree. And I think that's why investors are doing it on a sort of a company by company basis. It's not a one size fits all solution.
Yeah, that's true. So we got about a minute left, Bill. So I wanted to ask you what's coming down the pike. You know, it's always one of the benefits that we have with you being here is you get a chance to look ahead at the Delaware courts. Is there any issue that's coming down that sort of directors need to be, issues that directors need to be aware of?
Well, there's a couple things quickly, TK, that I could mention. One is there's legislation making its way literally as I speak through the Delaware Legislature that will, I think directors will have some interest in. One is part of the legislation will eliminate or prohibit fee shifting provisions that formerly might have been able to be used by companies to shift the cost or fees associated with litigation onto the losing party. And that's going to be prohibited under this legislation. The legislation will also make it clear that you can elect to have Delaware as your forum to resolve all internal corporate governance disputes, but you can also choose another forum, another state or another jurisdiction, but you cannot foreclose Delaware from also hearing those disputes. That's another piece of this legislation that I think directors would be interested in.
Well, Bill, I just can't tell you how enjoyable it is to have you on, us covering these topics. Again, we might have to move to a 3-part thing in the future, but thank you for joining us again on the show, and we'll have you back because we'll need, in 6 months, we're certainly going to need an update on all these issues and what's happening. And again, it's a pleasure to have you join us.
Thank you, TK. Always happy to be here.
And that will conclude this edition of Inside America's Boardrooms. We hope you enjoyed the show. We will be back again next week with another critical topic that'll help you be a better board member or committee member. So we'll see you then.
Join us again next week for Inside America's Boardroom, brought to you with Knowledge Partners, NASDAQ, the Center for Audit Quality, and PwC, along with content contributors Equilar, Meridian Compensation Partners, Wilson Sonsini, Goodrich, and Rosati, R.R. Donnelly, and the Society of Corporate Secretaries and Governance Professionals.